Yeah.
The question, it begs the question,
Yes, Your Honor.
what I'm saying is, if the case is assigned to you, will you recommend the release of inmates who yielded negative results in the drug dependency examination?
In the first place, Your Honor, I would have to qualify the answer. The reason for the detention is only because they are charged with or convicted with a drug-related offense. And if they have already served their sentence, then they are entitled to be released, Your Honor.
Do you think it's time to amend the Constitution in view of changes in modern times?
We are in the fourth industrial revolution, where the use of technology is a must for us to be able to cope with our neighboring countries. Been attending seminars, conferences in my capacity as Assistant Secretary of the Department of Trade and as Deputy Director General of the Anti-Red Tape Authority. I have encountered innovations in business, in which government agencies must also adjust to those innovations. So I think upon due compliance with the requirements of the Constitution, it's ripe for the Constitution, for our people to consider amending the Constitution, like allowing a higher percentage for allowing even non-citizens of the Philippines to utilize our natural resources without, of course, sacrificing the public trust doctrine that natural resources belong to the people, and if by contract that is delegated to a private entity, that private entity must hold the utilization of our natural resources in trust for the people and considering the general welfare of the people, Your Honor.
All right. My last question is, the Singapore-based Permanent Court of Arbitration issued separate decisions compelling the Philippine government in 2017 to pay 3.4 billion to Maynilad, and in November 2019 to compensate Manila Water 7.39 billion pesos for losses the two water firms allegedly suffered due to non-implementation of increases in water rates. Because of the onerous provisions of the government concession agreements with the two firms, the President is thinking of ordering the takeover of these water utility firms by the military. If the President does that, is that valid? Is that constitutional?
There must be due process, Your Honor. While we are bound as a nation to comply with the arbitral award, we have also a decided case by the Supreme Court in August 2019 in the case of three cases, Manila Water, and NW versus the Secretary of DNR, penned by in August 2019, Your Honor, where both Manila and Manila Water were adjudged to be in breach of their contractual obligation under Section 8 of the Clean Water Act, where they failed to comply with the obligation to set up waste treatment facilities and to connect the sewage system of subdivision local government units to their own. Because I believe that decision not only considered the water in violation of the contract, and if somebody will file a petition to void the contract or to cancel the contract on view of the breach of the contractual obligation, then that contract, the concession agreement may be cancelled or terminated. And I think the President is in possession of data or information for him to have given such information. But of course, there has got to be due process. Before he can order the military to take over, he has to first to cancel the contract, concession agreement with the water agencies, and the cancellation of contract requires a due process, Your Honor.
If you want to join the Supreme Court, your thoughts must be in sync with the issues. Your answers must be in reply to the question. So again, that is the correct answer to the wrong question. The question is, because of the arbitral award made in favor of the two water concessionaires, which award is being questioned by the government, the President threatened to let the military take over these utilities, public utility operations. The question is, if the President does that, is it valid and constitutional?
First, Your Honor, for the court to act on that, somebody has to file a petition questioning the
Well,
actual
of course, that's a given. Okay,
Yes, Your
that's a
Honor.
given. That's a given. So what's your answer, sir? Is
It
that
will not,
valid and constitutional?
because it will be in breach of the,
If the President orders the takeover by the military and a case is filed before the Supreme Court, and if you are in the Supreme Court and it is assigned to you, will you declare it valid and constitutional? That's the question, sir.
it will not be valid in constitution because military took over without annulling or rescinding the concession agreement would be considered in breach of the contractual obligation, so that the action of the President may not be considered as valid, Your
The
Honor.
government cannot, under any circumstance, take over the operation of public utilities?
Your Honor, under the Regalian doctrine and in the exercise of police power of the state, Your Honor, the executive can do so, of course, after observance of due process, Your Honor. And it can take over militarily the operation of, but first the contract, the existing contract, concession agreement with Maynila and Bastilas must first be
You are
annulled.
extremely malleable. You change your ideas from one spectrum to the other. The President also said he might be compelled to suspend the writ of habeas corpus. If he does that, is that valid and constitutional?
There's a constitutional provision for the declaration, for the suspension of the writ of habeas corpus when there is imminent danger to the security of the state. But of course, when the President suspends the habeas corpus, Congress must immediately convene within 48 hours, Your Honor.
Under the given problem of the public utilities, can the President validly suspend the writ of habeas corpus and order the arrest of officers of these public utilities
The writ of habeas corpus,
for alleged offense of economic sabotage?
the writ of habeas corpus is a writ issued by the court to produce the body of the person who is, but in this case, Your Honor, in the takeover of the Manila, the water of the water operator has nothing to do with habeas corpus, Your Honor.
That is the answer you give in a bar examination questions if you do not have a responsive answer to the question. All right. I just wanted to find out how you think. Do you think you're ready to be in the Supreme Court?
Yes, Your Honor.
You're ready. Ready to clash swords with the members of the bank?
Ready to agree, and if I disagree, I have to dissent. But, you know, in my experience as a lawyer,
So you're an agreeable person, but you're not judgmental.
no, judgmental in the negative, no, Your Honor. But if the good justice may allow me, whenever I think of something or I decide on something, I take time to research. And I do not decide instantaneously.
You will be given an average of 800 to 1,000 cases in the Supreme Court. You need time to research. how old are you now? 60?
60,
years
Your
old?
Honor.
If you're appointed to Supreme Court, it might take more than 10 years to finish the cases assigned to you.
Your Honor, the Constitution requires that for a decision to be rendered, it has, the facts and the law must be stated distinctly. And as a member, responsible member of the Supreme Court, any
Do
decision
you have, as a member of the Supreme Court, do you have to restate the same facts conclusively found by the lower courts?
only the pertinent facts, Your Honor, and the basis for the decision, Your Honor.
All right. Thank you and good luck.
Thank you, TM, sir.
Justice Mendoza is next.
Thank you very much, Chief. Attorney Perez, you were asked earlier by Judge Ilaw and Justice D. In essence, why would you choose you over your co-applicants who have judicial experience as a trial court judge, as trial court judges and as court of appeals justices? And you mentioned the 4 basic qualifications, and you also mentioned the other qualities of a good judge, which is under the Constitution. But you have not mentioned any outstanding assets of yours or experience which would compensate for this absence of judicial experience. Would you want to answer that again, those questions?
Honestly, Your Honor, my experience as a private law practitioner for 30 years should also be considered as a judicial experience. I do not want to compare myself with the esteemed members of the judiciary who are our co-aspirants to this position.
We are just asking you to help us be guided.
Your Honor?
We just asked that because we want you to guide us, to evaluate you. Of course, there's so many candidates, we have to make comparisons. I know that you need not compare yourself with others, but we want to be guided. Because there will be voting next January, we want to be informed.
Your
And
Honor,
information only come from you. You need not compare to the others. We know that you have no adjudicatory experience. What we are asking is what is your compensating asset.
if Your Honor, please, my work in the Anti-Red Tape Authority has exposed me to the problems of delay or processes in rendering government service and the clamor of the people for speedy justice. However, the Republic Act 11032 does not cover the judiciary and the legislature. I think by joining the judiciary, I can help the Supreme Court, particularly the Chief Justice, initiate or implement the reforms that are much needed to speed up the delivery of justice to the country, Your Honor. And once appointed, I undertake to finish or all pending cases assigned to me within 1 year from appointment. And if I do not meet that commitment, I volunteer that I will waive my salary for the first. So therefore, I will give myself a deadline. While the Constitution says a justice, Supreme Court has 24 months to resolve a case after it is submitted for resolution, I undertake to resolve a case within 6 months after the case is submitted for decision, Your Honor. And if I do not do that, if I do not resolve a case submitted to me for decision within 6 months, I also commit that I will waive my salary, Your Honor.
You put that in writing? And
Yes, Your Honor.
Okay, the Chief Justice is listening. You said that the law on anti-red tape does not cover the judiciary. In your practice, have you encountered or did you encounter red tape in the judiciary?
Not only in my practice, but even today, I have heard people, friends, complaining about delay in
Judiciary.
dispensing justice, Your Honor.
Yes.
In fact, I handled a case more than 10 years ago, a Sandigan Bayan case, where summons were served on my client 10 years after the case was filed in the Sandigan Bayan. And this is a recovery of ill-gotten wealth. And I questioned that. I raised that issue and delay, but unfortunately, I was not sustained.
Because maybe you included the fact-finding stage.
No, Your Honor. It's a civil case for recovery of ill-gotten wealth, and it took the Sandigan Bayan 10 years to serve the summons on the defendants, Your Honor. That is to me, and even now, the Mapasapana massacre, which is set for promulgation tomorrow, 10 years of trial, I think, is too long for me. And I hope that something must be done to improve the delivery of services. Like there's a revised rules on evidence and revised rules on civil procedure. I do hope that there will also be a revision of revised rules on criminal procedure where cases should also be resolved within a specific period. If a civil case is mandated to be resolved by the RTC within 10 months from its, the trial should be terminated within 10 months. And I think in a criminal case, there should be also a deadline for terminating the trial, Your Honor.
Yeah.
Maybe a little bit longer, maybe 1 year.
It's easier said than done.
Yes, Your Honor.
Because we were all trial judges. Sometimes we even if there was still no continuous trial, we observed continuous trial in Quezon City, especially the Chief Justice, who is an advocate of that. Anyway, you said you have an experience in the Red Tape Authority, but there are only two of you, the Director General and you. And what have you done in that office?
Even if we are only 2 regular employees, that
Yes,
we are
yes.
being supported by staff of
Okay.
about 70 who are serving on contract of service. And even there, we have filed charges already against a governor, against a mayor. We have ordered the Department of Public Works and Highways, the Department of Environment and Natural Resources, and Department of Air to automatically approve the request for extension of an application for failure to act on the application within the standard processing time, Your Honor. And the law, the Republic Act 11032, requires an agency to act on pending an application within appropriate time. Otherwise, it will be subjected to automatic approval. And that to me is a good scheme that will really speed up the process. And we have done that already. We have filed charges against government officials for violation of that law.
Should you not continue your good work there? There are only two of you and you're leaving the Director General, who even endorsed you.
The director is endorsing me to
You're
this.
going to leave him.
If the opportunity comes and I get the opportunity to be appointed, and I consider it as every lawyer's dream to be joining the highest court of the land, then I will do so.
He recommended you. He wants you out there? No.
We are very good friends, and he's very competent, and he believes in my capacity. Yeah.
Competence, you're going to leave him there alone.
That will also give him opportunity and time to recruit people that they can easily replace me. Or no one is indispensable in government service. If I get transferred, somebody will take my responsibility. And as I always say, no one is indispensable in government service.
Earlier, you were talking about the power of the president, and you mentioned Regalian doctrine. What is your understanding or concept of the concept of Regalian doctrine? Because you were talking about the power of the president.
The Regalian doctrine was illustrated in the case of, I remember that, where the ownership and the utilization of natural resources like water, energy, etc., belong to the state, Your Honor. So that if in the interest of general, that resources can only be utilized for the general welfare of the people, Your Honor. So that if it conflicts the with the, if an act of a private agency will counter or conflicts with the general interest of the people, then the president, in the exercise following the Regalian doctrine, can take over, Your Honor, even if there's an existing concession. But premise on the fact that that existing contract is still
Because of that
police power of the state in relation to the Regalian doctrine, Your Honor.
In relation to Regalian doctrine, you invoke police power to take over the operation or the utilization of the resources? Is that your answer? Anyway, we'll go to another point.
Yes, Your Honor.
How is jurisdiction? How do you obtain jurisdiction? What is your understanding?
Jurisdiction is conferred by law, Your Honor.
Yes, okay. Jurisdiction is conferred by law. In St. Martin's Funeral versus NLRC, the Supreme Court ruled that the administrative decisions of the NLRC should be first coursed through the Court of Appeals to a petition for petition and Rule 65. Because of the delay, the labor group asked that Congress enact a law returning the jurisdiction or increasing the jurisdiction of the Supreme Court by allowing direct appeal and through Rule 65 to the Supreme Court, bypassing the Court of Appeals. Can Congress do that?
So as the jurisdiction of the Supreme Court, Congress cannot do that, Your Honor, because the Constitution is very specific. The jurisdiction is conferred upon the Supreme Court under Section 5 of Article 8, and any legislation that will contradict that jurisdiction will be declared unconstitutional, Your Honor. Only the jurisdiction of lower courts can be conferred by Congress, Your Honor.
Only the Congress cannot touch the jurisdiction of the Supreme Court?
Unless the Constitution is amended or revised, Congress cannot touch the jurisdiction of the Supreme Court, Your Honor.
Under Article 6, I think, Section 8, Congress can increase the appellate jurisdiction of the Supreme Court with its consent. You review your Constitution on that?
With its consent, well, if the
Article
yeah.
6 of the Constitution,
Yes,
Constitution, it's not under Article 8. Aware of the graffiti in the underpass in Manila,
Your
Los
Honor.
Linat.
Your Honor?
The graffiti or in the underpass of Manila, like Los Linat.
Graffiti.
Are you aware of that?
I heard about it, Your Honor.
Suppose Manila, the city government of Manila issues an ordinance outlawing it. It was questioned before the Supreme Court, and you're applying the Supreme Court on the ground that it restricts their freedom of expression. What can you say about it?
Freedom of expression is not absolute, Your Honor.
Teaching
It can
remedial
be,
law.
it can be under the Constitution, the state in the exercise of police power can under the exercise of police power, the city of Manila can by ordinance ban that, because not only because to me it is not a legitimate exercise of freedom of expression, because it is a public place. They can always and the graffiti in the Manila underpass is a public property. No one can legally put graffiti in it, and the City of Manila has the authority by passing that ordinance to ban anyone from putting any graffiti on that public property.
General restrictions on the freedom of expression.
Number one, Your Honor, is that the police power of the state and in the interest of the general welfare of the people.
Freedom of expression. Freedom. I'm asking about freedom of expression. I'm not asking the principles underlying the Constitution. You're always invoking police power. I'm asking freedom of expression. What are the restraints, restrictions?
Freedom of expression, as I said, is not absolute. Number one, the restrictions, yeah.
You gave that answer earlier.
Yes, Your Honor.
What are the two general restraints or restrictions of the freedom of expression?
First, it does
One-
not endanger.
One covers what you already stated.
First, the freedom of expression does not endanger public safety or security, Your Honor. And another restriction, that freedom of expression must be exercised in a legitimate way, that it will not adversely affect or influence other people's rights, Your Honor.
We read Diocese of Bacolod versus Comelec.
I heard, I must have encountered it.
You are teaching remedial law.
That was a long time ago already, Your Honor. That was about
This
8
case
years
is
already.
2015.
2015.
Oh. But you keep abreast of the latest laws and jurisprudence.
I try to, Your Honor.
Yes, you are applying in the Supreme Court.
I try to, Your Honor.
So anyway, it seems that the first one is content-based restraint, and the second is content-neutral government regulation. You remember?
Yes,
You remember?
I have a recollection, Your Honor,
You
but
correct. What is content-neutral government regulation? Content-neutral government regulation.
content neutral. I've not read the original application.
It controls the incidents of the speech as time, place, and manner of the speech. Now, with respect to what was written, what is the restriction there?
I do not know what was written in the graffiti, Your Honor. Are you referring to the graffiti in Manila, Your Honor? If what is written has no
They
relation
said
at all.
They wrote their grievances against the government.
But express their grievances by, in some other way, in some legal way, by perhaps seeking an audience with the official concerned and maybe writing.
That is a restriction. You're defining a restriction. That restriction,
To repeat, Your Honor.
that restriction, you are describing it. I already mentioned it. Intent-based restriction. Okay. Now, you are a practitioner, you want to go to the Supreme Court. You are the lawyer of those who wrote the graffiti. File, you wanted to, or you want to, your clients want to challenge the ordinance. What are the two types of challenges in the Constitution? Case.
If I were to represent the persons who are being judged for
Yes, yes. Oh, you're going to the Supreme Court. You want to challenge the ordinance, the constitutionality of the ordinance.
Your Honor, I would probably hesitate to take the case and challenge because I believe
You will hesitate.
to accept the case, Your Honor, because a lawyer may also
Tinanggihan mo na
refuse.
kaagad. Tulungan mo sila o anong gagawin mo?
I'm sorry, I really do not to,
you
because my
did-
impression is that
You did not teach it. Oh, what is the difference between facial challenge and as-applied challenge?
as what, Your Honor?
Facial challenge and as-applied challenge.
Facial challenge is you attack the legality or constitutionality or law or on its face, Your Honor. If an act or law or regulations is on its face questionable, then you can challenge the constitutional or legality of that act or law or regulation. But even assuming that a law is legal or valid, but when it is misapplied, then there's a difference. They can challenge the action with allegation that there is a wrongful application or enforcement of a law, which is not within the intention of the legislative authority, Your Honor.
If you will question the ordinance, what is that? Facial challenge or as-applied challenge?
Facial challenge, Your Honor.
Not as-applied. How do you define facial challenge? As a facial challenge.
If the ordinance, I'm sorry, Your Honor, but I thought we're referring to another case. If the ordinance, law or regulations is on its face irregular, illegal, or unconstitutional, then I can attack the legality of that ordinance, Your Honor. But when, as applied, when there is wrongful enforcement or application of that, then I can also attack on that aspect, Your Honor.
Okay. What is the right to equal protection under the Constitution?
The equal protection law guaranteed by the Constitution under Section 1 of Article 3 of the Bill of Rights guarantees all citizens of the Philippines to be protected by law and should be entitled to the benefits of the law, and that no preference or no advantage should be given over a particular sector or segment of the population, meaning the law should apply to everyone, Your Honor.
What is the exception?
The exception to the equal protection law, again, Your Honor, is think,
where there is a valid distinction. Okay? In Mosqueda versus Filipino banana growers, what is the test to determine reasonability of a distinction and sufficiency of the justification? The valid distinction.
Your Honor, I have not read the case of Mosqueda.
No, it's in the books. Even Mosqueda just cited the books. What is the test?
Of course, first there must be a reasonable distinction, Your Honor.
Yeah, the test to determine reasonability of the distinction. Earlier you said you did not know the exception. I said you can make a distinction when there is a valid substantial distinction. Now I'm asking you now the test to determine the reasonability of the distinction. What do you call that test?
It escapes my mind, Your Honor. I'm sorry.
Means and test. Anyway, what are the three levels of scrutiny under the Equal Protection Clause?
I'm sorry, Your Honor. It escapes my mind right now. But if given the opportunity, I can
They are always
study
escaping.
it, Your Honor.
They are always escaping. Ano pa ba ito? I'll ask you a question. Decision mo. May tatanong akong decision. In your practice, have you handled writs of possession? Writs of possession? Or issued ex parte? Issued ex parte?
To my recollection, no.
You teach remedial law. It's there.
Time, Your Honor.
You teach remedial law. Oo. When a writ of possession is issued ex parte, when do you not enforce it? When should the court conduct a hearing?
Come again, Your Honor.
Usually, writ of possessions issued ex parte. So there is no hearing, only one side. Kaya you call it ex parte. When do you conduct a hearing?
There is doubt or question as to the right being asserted to by the complainant or the applicant, Your Honor. A court has to be enlightened, and that requires a hearing, and that there is no clear and concise allegations that would convince the court to issue the writ of possession ex parte. Then the court, in the exercise of sound discretion, will call the case to hear.
The rule is that you do not implement a writ of possession issued ex parte when there is a third-party claimant in possession of the property holding it adverse to the obligor. That is the Barcera case decided by our Chief Justice. Listen carefully. There was an information filed for Stapa under paragraph 2A, article 315 of the revised penal code, filed against an accused, and a warrant of arrest was issued subsequently. 4 years later, the accused, while still at large, filed an omnibus motion ex abundante ad cautelam to quash warrant of arrest and fix bail, alleging that it was only recently that he was able to find a lawyer, etc., etc. Now, if you were the judge, how will you rule on the motion?
I will deny the motion, Your Honor, because a party to a case should get a counsel, and there is no excuse for not getting a lawyer earlier than 4 years, because the Constitution even guarantees that any citizen can avail of assistance of government, and poverty is not the reason for it. So there should be no excuse at all for not availing of the services of a lawyer, and that is not an excuse for quashing the warrant of arrest, Your Honor.
And can he act on the motion because he is still at large?
Of course, the law requires that he must first be surrendered,
That is
and
the
that he
general
must
rule.
serve the warrant of arrest. He must voluntarily surrender to the court before the court may even grant relief, Your Honor, to the accused.
So he must be in the custody of the court first.
Yes, Your Honor.
So he cannot favorably act on that motion ad cautelam.
Yes, Your Honor, because I think it's a litigated motion, and of course the accused, being the subject of a warrant of arrest, must first present himself and be subjected to the jurisdiction of the court, so the court can act on the motion ex parte, Your Honor.
Well, the answer is that the court can act on the motion to quash the information and to fix bail, even if he is not under custody. To fix bail is different from praying that the custody of the law is required before the court can act upon the application for bail, but it is not required for the adjudication of other relief sought by the accused, as in the instant omnibus motion to quash warrant of arrest and to fix bail. You know, that Padua versus people who penned that. Chief Justice. That will be my last question. You're not reading the decisions of the Chief Justice.
So, you have been there for more than or almost 2 hours, no? And we have still 4. The other 4 will be interviewed by a panel. Okay, okay. So I just ask a few questions. Are you the same Attorney Perez who used to appear before us in the fiscal's office in the late 80s and the early 90s?
You were then a roommate of
I
then
was-
Judge Bermejo, Your Honor.
Yeah, I was looking at you, and I do not know. You have aged a little bit, like me.
Long
also.
time ago, Your Honor, Chief Justice.
Yeah, I just want to have some clarifications based from your answers now. That case, I'm interested about that case in Sandigan Bayan, where the summons were served 10 years after the petition was filed.
Someone's, yes.
Your client is the respondent.
One of the respondents, Your Honor.
So it is a petition for recovery of ill-gotten wealth.
Yes, Your Honor.
Now, under the power of the PCGG, that case was filed by the PCGG.
Yes, Your Honor.
So that might have been filed as early as 1987, because the PCG cases were filed during the Freedom Constitution
Yes, Your
to
Honor.
expedite the cases. So may I know why it was only filed 10 years ago?
I do not also understand, Your Honor, because the address on record of the defendants were a matter of record, and it's within Metro Manila.
Do you think that it would have been better for you to voluntarily appear? Because appearance of a party in a civil case that will serve already or satisfy already the jurisdiction of the person of the defendant in a civil case, without waiting for the summons. Anyway, you're aware that there was a petition. So why did you not voluntarily surrender?
In the first
Or
place, Your
voluntarily
Honor,
appear
in the
and
first place, Your
file a
Honor,
manifestation?
in the first place, Your Honors, my clients were not aware of the filing of the petition against them. They're not even aware that they were one of the parties in that case, Your Honor.
Yeah, okay. Anyway, let's go to the other. Now, do you know what's the difference between criminal process and criminal action? Because I was listening to you, about your answers regarding the issuance of a search warrant. A search warrant, according to you, can only be issued and then enforced within the territorial jurisdiction of the issuing judge. That's what you said, di ba?
I have,
That's what you said. Yeah. Does the Constitution so provide that must be issued only within its territorial jurisdiction?
I'm sorry, no, Your Honor.
Now, is there therefore a difference between criminal process and a criminal action? How do you consider a search warrant and a warrant of arrest? Are these not criminal processes?
The warrant of arrest is a criminal process, Your Honor.
Also, a search warrant is a
Criminal process, Your Honor.
So if it is a criminal process, do we apply the principle of jurisdiction over the subject matter?
I stand corrected, no, Your Honor.
Can you enforce a warrant of arrest issued by an RTC or an MTC judge anywhere in the Philippines?
Yes, Your Honor.
So it does not provide for territoriality as
Yes.
far as enforcement.
Yes.
But when it is a criminal action, then you have to apply territorial jurisdiction because the jurisdiction is only applies only as to the jurisdiction where the court is sitting, you know.
Yes,
So
Your Honor.
in other words, where the crime was committed. Now the other clarification that I want to ask from you is that the anti-red tape law is not a law that issues a duplicity, no? To me, is it not that a duplicity? Because under 6713, government officials are supposed to respond within 15 days from receipt of any inquiry. The law on the code of conduct, that is the law on code conduct of government officials, that law has been there for a long, long time, even in the early 70s, early 90s. And the law requires that every government official should respond to any inquiries within 15 days from receipt of the notice.
With all due respect, Your Honor, Chief Justice, Republic Act 11032 is not a duplicity in the sense, Your Honor, that the law specifically requires government agencies to act on an application or request within a standard processing time, either 3, 7, 20 working days, subject only to one extension. Yeah. And if the government agency fails to act on the application within that standard processing time, the law says the pending application or the pending request for extension will be deemed automatically approved. And it also subjects the erring employee to criminal and administrative and civil liabilities.
But it also covers situations where queries may be asked, and then you have also to respond under the anti-red tape law. That's one of the That's one of the purposes of the anti-red tape law. Now, I also asked that question because this law became effective in 2016. When did the law become effective?
2018, Your Honor, June 17,
2018. This is one of the reasons why in the ease of doing business, we had a big jump from our ranking in the ease of doing business. Is that one of the reasons?
One of the reasons, Your Honor, which precipitated the enactment of this law is really because of our low ranking in the World Bank Doing Business survey. And one of the aims really, once this law is fully implemented, will not only improve efficiency in government service, it will likewise improve our ranking by the World Bank, thereby attracting more investors to come in, because investors would look at the survey with consideration before they decide to invest in the country.
But that's only one of the factors or one of the bases. Can you mention other factors or bases why we jump to a higher ranking in the ease of doing business?
Also because of the perception of the anti-corruption campaign of the president, that he always says that at the whiff of corruption, any public official or employee will be prosecuted and, if possible, be fired, Your Honor.
Have you learned that one of the factors that they consider is also the performance of our courts in the enforcement of contracts?
In fact, Your Honor, that is also one of the 11 indicators in the ease of
That's
doing
why
business.
I was waiting for you to mention
Yes.
the court.
Yes,
And we are always talking about your functions in the anti-red tape. I think that's one of the factors in determining the ranking of the Philippines in ease of doing business. Have you heard about small claims cases?
Yes, Your Honor.
And do you think that's one of the factors why our ranking went up
Yes, Your Honor. That's
by, I
also
think,
one of the
25
factors.
ranks? Yeah.
Yes, Your Honor.
But in small claims, the reason why we are very fast in resolving small claim cases that lawyers are not allowed to appear. So are you in favor of that?
As a result, it expedites the process, Your Honor.
Yeah. Probably now you're not in favor, but if you join the court, then you will not be in favor because you will not be receiving any professional fee. Am I correct?
The business of a lawyer is not just about professionally, it's really more of the delivery of justice, Your Honor.
Now, one of the problems of delay in the resolution of cases are probably one of the problems that there are some rules that have been there for a long time. No? I want to specifically mention about testate in testate proceedings. Have you handled testate in testate proceedings
Yes,
before?
Your Honor.
And how long did it take you to finish a testate and intestate proceeding?
Years, and perhaps it did not even end with a court resume, but the parties entering into a compromise agreement. Because of the delay, parties would eventually just enter into
Now,
a amicable settlement.
I will now ask a question. If you join the court, what suggestion are you going to give us or to give to the court in order to expedite the resolution of testate and intestate proceedings?
There should also be a timetable for termination of cases in testate and intestate.
It's easy to say there must be a timetable, but in the rules themselves there are provisions that might have to be amended in order to expedite the resolution of testate and intestate proceedings. Do you think that we have to take away multiple appeals in testate and intestate proceedings?
Yeah, I think so, Your Honor, Chief
I
Justice.
think that's the one that actually delays testate and intestate proceedings, because if there is a question as who are the compulsory heirs and the decision is adverse to a party, then a party can appeal that resolution, that decision, although it's not final because we allow multiple appeals. You study the rule on testate and intestate proceeding so that we can also come up with new rules to expedite the resolution of testate and intestate proceeding. Now, you were talking about reglementary period. So have you read, you mentioned about civil cases to be resolved within 10 days, within 10 months. Yeah. So you read in the papers what we have published last Saturday, that we are implementing amendments to the rule on civil procedure effective May 1
Yeah,
of
2020.
next year. You read the
Yeah,
rule?
yes, sir.
What struck you most, and so far as the amendments are concerned?
There is really a clear-cut timetable, and there is really a mandatory requirement that trial should end within 10 months or
Yeah, because it's very easy to say that
And
should
that-
be resolved within 10 days.
and then also the requirement
10 months
of
rather.
attaching judicial affidavits to a complaint, and then it will also subject the lawyer for liability in case there's misrepresentation, and it really will now, with the implementation of that revised rules, will really prevent delay because lawyers will not be at liberty to just keep on filing motions for postponement.
Yeah. Did you try to analyze the pleadings that are supposed to be filed? Now, if you are a practitioner, do you agree that by limiting the pleadings that are to be filed, then the income of the lawyer might be reduced considerably? Because some lawyers are paid by the pleadings that they file. There are many pleadings that are not supposed to be filed.
Not generally true for all lawyers, because a professional fee is not only based on the pleadings filed, but may also be based on the success. So if the case can be terminated as early as possible, then that will also compensate for the lawyer's fees, Your Honor.
We have also limited the number of hearings because by putting a period within which to terminate the presentation of evidence, then there will be, in effect, there will be a limit of hearings that might be set by the court. So lawyers will lose some income because there will be less hearing, less appearance fees.
Well, that will prevent delay and will certainly assure parties of a speedy trial. Then the matter of lawyers getting more fees should be inconsequential and of no relevance at all.
You want also to amend our rules on criminal procedure because you, according to you, 10-year period, the 10-year period to terminate that case of Bumps 1 is too long, right?
Your Honor.
Now, why do you say that? Just because it lasted for 10 years, there's already undue delay?
Well, there's a saying that justice delayed is justice denied. For the victims of the mass, especially the families, 10 years would be too long, Your Honor. And also, the risk of losing witnesses will be there. In the criminal case, we cannot, that's why I may even propose that in the revised, that witnesses should be adequately protected. If they can be confined and protected by the state while the case is pending,
Yeah.
I think I would suggest that, Your Honor.
But there are more than 100 accused. And there are how many victims? I think there were more than 100 witnesses, both from the prosecution and the accused. And how many victims were there? I think there were 52 or more than 50 victims. Do you think that that 10-year period is too long, considering that we have to avoid due process? You were talking about due process.
There has
but
got to be a way.
every accused is entitled to due process. You know that.
Yeah, I know that, Your Honor, yes.
Yeah. So
But
are you
the
going to
10
change?
years is just simply too long. Your Honor. But if I may suggest,
the
you consider,
judge,
perhaps
the-
we can take a second look at the process, Your Honor. The law said that in a criminal case, the accused is presumed innocent until proven guilty. Therefore, the prosecuting masters has to prosecute the case, presenting evidence. In a very exceptional case, where the facts and circumstances will allow the shift of the burden of proof, maybe the Supreme Court can study this, that if an exceptional case like this, that when the facts and issues are clear, and the presence of the accused or in the scene of the crime is not disputed, perhaps we can shift the burden by allowing the defense first to present and counter balance the presumption of presumption.
That's the problem because it's easy to say that, but lawyers will not allow it. The lawyers will always say the burden of proof is on the prosecution, so we have to listen first. Because even if the burden of proof lies with the prosecution and there's no sufficient evidence, we do not even need to present our witnesses because the guilt or the innocence of the accused is solely based on the evidence of the prosecution. They will always argue on that.
Your Honor, Chief Justice, lawyers can always argue, but if the Supreme Court says so, being the highest court of the land, and if the Supreme Court...
Have you read the special rules or guidelines on continuous trial?
In a way, yes, Your Honor.
Yeah.
But I don't know if I can recall every bit or every provision.
We
of
have
it.
also adopted judicial affidavits as the direct testimony of witnesses in
Yes.
most cases.
I was able to...
We have required all judges to enter into stipulation.
But in the criminal cases-
then impose disciplinary actions against judges who do not cooperate in pre-trial. Are you in favor?
If I'm in favor, if
Yeah,
that will
okay.
speed up the process,
Yeah,
I'm in
because
favor.
that's already promulgated.
Yes,
so
Your Honor.
you can no longer complain.
Yes.
So we still have 1 hour, no? For the okay. So that's all, Attorney Perez. Nice to see you again, no?
Thank you, Chief
Yeah.
Justice. Thank you, honorable members of the Judicial and Bar Council. Thank you for this opportunity.
I've not seen you for a long, long time. Yeah.
I've seen you about 4 years ago, 5 years ago in a hotel, and I approached you and you said you tried to encourage me to join the judiciary, Your Honor,
Did I
because
say
of
that?
the attractive retirement
But
package.
I did not say in the
I
Supreme
hope you
I
will
did not say-
remember.
I did not say in the Supreme Court.
No, not say, sir. But it's matter of fate, matter of destiny, Your Honor.
Sige, thank you, ha. Thank you.
Justice, thank you, sirs, justices, Judge Ilaw. And, po.
Thank you, Deputy Director General.
the Supreme, the court, I think the civil procedure that is being supposed to be adopted at the beginning May of next year. One of them is the non-filing, the disallowance of filing of motion to dismiss. And there should be no reply and no rejoinder to be filed unless there are actionable documents involved, Your Honor. So I think this is one way of declogging the
But
court.
there's no, the actual document that you're talking about is something that is raised in an independence answer. And there is a compulsory counterclaim. And
Yes,
he
if there
raises
is-
an action document in the answer, then you have to require the plaintiff to file a reply, But anyway, the quantum of evidence required in filing cases before the RTC, what's the quantum of evidence required
Well,
in
as to the
filing a case before the RTC?
criminal case, there must be a probable cause, Your Honor.
So probable cause.
Yes, Your Honor.
The requirement of probable cause is lower than the requirement of a prima facie case.
Yes, Your Honor.
So in other words, that is the lowest threshold of evidence insofar as filing of cases is concerned. Now, we also encounter some cases involving preliminary investigation conducted by the fiscal's office where you do not allow defenses that are raised in a preliminary investigation on the ground that the defenses should be better traced out in a trial proper. Do you know that? That's what you usually do in the fiscal's office. So in other words, you cannot put up any defense. If that is the resolution, that it can only be traced out in a trial, then any defense that may be put up by the respondent in the preliminary investigation will not be entertained. Do you get me?
Yes, Your Honor.
Is that correct? You cannot even resolve a question of credibility. A question of credibility on the part of the arresting officers. Then you file the case on the ground that it's only the court that can determine the credibility of the witness because there's no cross-examination in a preliminary investigation, and that's the only way to impeach the credibility of the witness. That's what you say, no? So all of these reasons, require, because you do not anymore resolve all these reasons, then you file the cases before the RTC. So I will ask you now, what remedy? How should we remedy those kinds of resolutions
Well,
where defenses cannot even be available in a preliminary investigation, so that they will be, instead of filing all these cases, similar cases, they will no longer be filed.
well, Your Honor, if the quantum of evidence right now required before the prosecutor's office is probable cause, there is a probability that the crime has committed and the one who is being accused is the one who committed the crime. But since it was stated by the Honorable Chief Justice, Your Honor, the quantum of evidence may be raised to prima facie, Your Honor, and in as much as the Supreme Court has the rule-making power to do so, Your Honor, it may change the quantum of evidence required to be, with regard to the prosecution evidence, before the same could be filed with the regional trial court, Your Honor.
I will ask Justice Garland, you came from the MTCN,
Yes, Your
first
Honor.
level court, to
Yes, Your
the second level court. Now, under the rules, crimes punishable by 4 years, 2 months, and 1 day are subjected to preliminary investigation, right?
Yes.
But all those crimes punishable under 4 years, 2 months below, there is no need of preliminary investigation. And this has been one of the reasons why there have been a lot of cases filed before the first level courts. Because if the penalty is 4 years, 2 months below, there is no PI, there's no preliminary investigation. What the fiscal will just do is to attach the affidavit complaint if the case was filed before the fiscal's office, or the affidavit of arrest if it is directly filed by policemen, then filed before the first level courts. Am I correct?
Yes, Your Honor.
That's the procedure.
Yes.
And then because judges, when they receive the information, they immediately issue a warrant of arrest. Unless, of course, if the cases are covered by the rule on summary procedure, there is no need of issuing a warrant of arrest. It's merely summons. to acquire jurisdiction over the person of the accused. Okay?
Yes,
Do you
Your
confirm? So there are a lot of cases being filed also in the first level courts for crimes punishable by 4 years, 2 months below. Now, if you join the Supreme Court, what remedy are you going to suggest?
Yes, as you have stated earlier, Your
No,
Honor.
without talking about the quantum of evidence required. Because, you know, that quantum of evidence required, you were not yet lawyers probably at that time, they changed the quantum of evidence twice. When there was a public prosecutor, it used to be prima facie. And then they changed this to probable cause. Then there was even a time when judges were authorized to conduct preliminary examination before the issuance of warrant of arrest, but all judges were complaining because it was actually double work, because there will be so we cannot go back to that procedure anymore. That will not be, I know that some of justices may not allow that, but there must be a remedy to that kind of situation where informations are filed immediately without any PI. What do you say to that?
Yes, like my experience before when I was still in the municipal trial court, Your Honor, we even have the jurisdiction or the authority to conduct a preliminary examination when cases cognizable by the regional trial court. So we ourselves conduct preliminary examination, then we will submit a resolution to the fiscal, and then the fiscal will can even overturn us. Now, and as much as you have stated earlier, Your Honor, about the quantum of evidence, to my mind, my suggestion, Your Honor, is that we must have to amend the
Rules.
yes, Your Honor, in the sense that because if the quantum of evidence is based on a probable cause for purposes of filing a criminal case, the practice, Your Honor, of the public prosecutors, because it's so easy to file a case if the quantum of evidence is based only on probable cause. Unlike when the quantum of evidence is based on prima facie, at least the fiscal has a leeway even to, at that stage, Your Honor, they can already dismiss the case because of the quantum of evidence.
Problema kasi sa prima facie threshold ng probable cause. If this probable cause, yung fiscal file ng file eh.
Yes, Your Honor,
They always
that's why.
file because they will dismiss the case, they will be suspected of something. Now, if you use quantum of evidence prima facie, then fiscals will not file. Then they will also be the subject of suspicion that they did not file because something else. No, that's also a problem. So anyway, I'll ask Justice Perez another question. Your practice, Attorney Perez, when you joined the Court of Appeals was what? More on civil cases?
Your Honor, I was in a law firm and we dealt with various cases of all nature.
Yeah. So what mostly probably civil cases. Not so much on criminal cases and administrative law.
Not so much in criminal cases, Your Honor.
More on civil cases.
Yes, that's correct. Until I joined, I became a general counsel, Your Honor, of a corporate group.
Corporate group. So I will ask you questions about what judicial reforms insofar as expediting the resolution of special proceedings. Special proceeding cases.
Yes, Your Honor.
Can you suggest, because we have not yet come up with the special rules on special proceedings. We are already through with civil procedures and the rule on evidence, and we have also have some special rules.
Yes, Your Honor. In the case of special proceedings, of course, the proceedings that take so long to resolve, because there are several issues and several appeals available, will be the settlement of the estate of a deceased person. The other kinds of special proceedings, Your Honor, are more or less summary. But in the settlement of an estate of a deceased person, we know that it can take very long to settle this. And I think if we are to improve on the rules on special proceedings, we should pay attention to more expeditious
Can
settlement of
we
estates.
also adapt and simplify petitions, the petitions or pleadings that are filed in settlement proceedings? Can we also simplify?
Yes, Your Honor, I think
Like what? Like what?
our proceedings in the settlement of estate is, my impression is archaic. And I think that we have a long waiting period, for example, before the claims are filed under Rule 86. And I think we can actually do simplify a procedure where the claims are filed earlier.
I mean, simplify the pleadings that are filed, limit the pleadings that are filed, probably prevent the filing of Rule 65 of interlocutory orders and so on. Can we do that in special proceedings?
I think we can do that, Your Honor. In fact,
Like what? Like what?
those orders which are not appealable under Rule 109 and considered interlocutory, we should prohibit already a review by a Rule 65 on these issues.
Yeah.
And in fact, I think also, Your Honor, we should consider also reviewing the appealable orders under Rule 109 because the multiple appeals allowed under Rule 109, every time an appeal is taken from an appealable order, will obviously delay the proceedings likewise.
Now let's go to replevin.
Yes, sir.
Replevin cases. Replevin is a provisional remedy at the same time is an action itself, a principal action in itself.
Yes, sir.
When does it become a principal action?
The replevin becomes a principal action, Your Honor, when the civil action is for recovery of possession of personal property.
Well, that's the provisional remedy. The principal action is recovery of sum of money, because the most personal property is pledged in order to satisfy summary judgment. It's a provisional remedy because in the meantime you can take possession of the property, but your main action actually is to recover some sum of money.
Actually, Mr. Chief Justice, I can imagine a case where the main action is for recovery of personal property.
Yeah, that's correct. That's
And
correct.
then-
But under the rules, it is a provisional remedy.
Well, there can be a provisional remedy in that case, Your Honor, because being personal property, it is by nature mobile and easily hidden.
Yeah.
And therefore,
Now, so my question is this, how can we expedite the resolution of replevin cases? There are so many replevin cases that are being filed. And are you familiar with the rule on small claims?
yes, Your Honor, a little bit.
Or replevin, because if you consider that is a principal action in replevin cases, that cannot be the subject matter of a small claim.
It cannot be, Your Honor, yes.
So how do we remedy? How do we remedy this problem of so many replevin cases? If it's not covered by the small claim, assuming that the amount is within the small claim, then how can we remedy if your position is replevin, is recovery of possession of property, and it's not covered under a small claim? How will you remedy remedy in order to expedite the resolution of replevin cases?
Actually, Your Honor, in the present formulation of the small claims rules, then that kind of action is not governed by those rules. But
Yeah.
there is, I think,
That's why
no-
I was saying, if it is a recovery of sum of money, that can be the subject matter of a small claim. Because as long as the amount does not exceed 400,000, because that is the maximum amount is small claim. But if you claim that replevin is also a main action, which is recovery of personal property, definitely that cannot be the subject matter of a small claim. That's why I'm asking you, if that is your position, how will you expedite the resolution of replevin cases? Because there are too many replevin cases in the RTC.
My proposal, Your Honor, will be to amend the rules on small claims to include a claim for personal property of small value. I think the rules of court recognizes that in actions where small value a property of small value is involved, that the court can actually come up with summary proceedings.
Do you Justice Singh? Yeah. Your rank now
Yes,
is,
Mr. Chief
what
Justice.
is your rank? Justice
I
Singh?
am,
Your
a s-
ranking in the Court of Appeals, what is now your rank?
I'm number 31, Your Honor, in
So you are
Manila
st-
Station.
You're still a junior member of the court.
Senior, Your Honor.
Senior already?
Yes,
so
Your
that's
Honor.
all. Now, my question is this. You're an outstanding judge, I know, because you were an outstanding MTC judge, right? And you've been a member of several committees, no? One of which is the subcommittee on the revision of the rules on civil procedure, no? Now, if you're familiar with this rule on civil procedure, may I know, if you join the court, what judicial reforms are you going to introduce in order to expedite the resolution of cases, knowing fully well that is one of my goals, why I am the Chief Justice. I want to expedite all the resolution of cases. That's why most of my questions are geared towards judicial reforms in order to expedite cases. So you join the Supreme Court, aside from those that you have been part of the committee that amended the rules, what other suggestions are you going to give?
Thank you, Mr. Chief Justice. Perhaps one of those will be about Rule 42, Mr. Chief Justice.
Petition for review?
Yes, Your Honor. I wrote a paper on that, and my position or my suggestion is that allowing a third review from cases originating from the Metro TCs is too much, Your Honor, because if your case originates from the RTC, you're only allowed to go to the CA and then to the SC if the SC will entertain your petition. But if it's an MTC case, you go to the RTC, then you have a petition for review with the CA, and then you can still go to the Supreme Court if it will entertain your petition in its discretion, Your Honor. So in my paper, I suggested that we have to put an end to that, at least with the CA, so to spare the Supreme Court from having to review ejectment cases, BP 22 cases. That's one of the things that I thought we could suggest, Your Honor.
Okay. So, in the exercise of the appellate jurisdiction of the RTC, you have to go to the Court of Appeals under Rule 42.
Yes, Mr.
But
Chief
in the
Justice.
exercise of its original jurisdiction, you go to the Court of Appeals on ordinary appeal.
Yes,
That's correct.
yes,
Yeah.
yes, Mr. Chief Justice.
Now, you were one of the pioneers in the adoption of the rules on small claims. Yeah.
Yes, Chief.
But fortunately, you will not anymore a part of the 2015 revision of the rules, because at that time you were already with the Court of Appeals, and you were assigned in Visayas and Mindanao. Okay. So my question is this, no? The rules say in the guidelines, because that's why I wanted to have some opinion from some of the justices, because I'm thinking of this, no? So, any small claim is not appealable because the finding facts are final. Because the cases are simple, that's why we only limited the application of the small claim to sum of money arising from mortgage, arising from promissory notes or service and so on. That's why we limited the application. And the only remedy, if you lost you are the borrower, no? That's why I was telling the Attorney Perez a while ago that you can still appear in the small claims, but not as a lawyer, but as a borrower. If you do not pay, then you will become the respondent. So if you lose in the first level court, you go to the RTC, the only remedy that you can invoke is Rule 65. So certiorari Rule 65 on the ground that the MTC probably gravely abused discretion in rendering a decision. But that Rule 65, if denied by the RTC, then probably only remedy is Rule 42, a petition for review. There are many cases that reach us about a small claim, but that case should have already ended in the Court of Appeals. So the remedy, if the loss under Rule 65, in the RTC, you go to the Court of Appeals, they make use of Rule 42, because there is no other remedy except Rule 42. But some of our justices resolve all those cases, resolve the cases, and then try to review the facts. I have two cases that reached the Supreme Court, and I was surprised why it reached the Supreme Court. That should have already ended in the Court of Appeals. So, do you agree with me? Is that what you are thinking about?
Yes, Mr. Chief Justice, of course, I agree with you. And of course, Mr. Chief Justice, The objective precisely of the rule on small claims is to make those decisions not appealable and immediately executory.
Yeah, that's correct.
So it will be defeating that very purpose if we allow multiple reviews
Yeah.
after the MTC renders a decision.
Because you can only raise question of law on a petition for review under Rule 42. What law can you question when the small claim is a rule promulgated by the Supreme Court? So can you question the rule of the... But there are still justices of the Court of Appeals that render decisions and then review the facts. So I'll go back to the question of Rep. Levin. Now, can we come up with a rule that cases decided by the first level courts, if they are brought to the RTC, for the RTC on appeal, and then the facts are sustained by the RTC, can we declare that the judgment becomes immediately executory and that the finding of facts of the first level court sustained by the RTC are considered final?
Certainly, Mr. Chief Justice, the Supreme Court has that power.
Yeah. So that if the decision of the RTC sustains the decision of the first level court and then the finding of facts are declared final and executory, then the only remedy is what? Rule 65. Because you cannot file a petition for review, the only remedy probably is Rule 65 and then show that the resolution or decision of the RTC was, the court gravely abused its discretion in rendering the decision. So the process will end there, probably, I hope. Can we do that, Justice?
Yes, certainly,
Okay.
Mr. Chief Justice.
Okay, now I will ask Justice Lopez again. The rules say in the rules on criminal procedure that if it is a crime punishable by reclusion perpetua, life imprisonment, or death, and then therefore the crime is non-bailable, you have to file a petition for bail, right?
Yes, Your Honor.
Yes, of course. You have to file. If you say no, I will not consider you anymore.
Yes, Your Honor.
You took your time to answer the question.
No, I thought there's a follow-up question, Your Honor.
Yeah, okay.
So I was
So
waiting
no.
for the follow-up
You have
question.
to file a petition.
Yes, Your Honor.
And what's the purpose? Why do you have to file a petition for bail?
Well,
Why should the accused file a petition for bail?
because
It's not bailable, right? It's not bailable, eh.
it's not bailable if the evidence is strong,
No.
Your Honor.
You recommend, di ba? Fiscal
Yes.
recommend no bail.
Yes.
Because it involved a capital punishment or reclusion perpetua. So the only remedy in order to enjoy provisional liberty is file a petition for bail.
Yes, Your Honor.
The purpose is what?
Because it's up to the court to decide whether to grant or not
Okay.
the bail, Your Honor.
Through a hearing.
Yes.
In order to determine.
There must first be a hearing, Your Honor.
In order to determine if the evidence of guilt is strong or not.
The evidence of guilt is strong. Your
Can we do away with the hearing? Because in petition for bail, it will take time, a lot of time, to hear and resolve a petition for bail. Can we just say under our rules that there's no more hearing?
I don't
And
think
in
so,
order
Your
to
Honor.
abbreviate proceedings?
If it's
no more
lower
hearing.
than reclusion perpetua, probably
yun
it
na
can
nga
be
eh.
done, Your
Di
Honor.
reclusion
because-
perpetua nga pa rin.
But if it's a reclusion perpetua, there must be a hearing. Anyway, what the evidence received during the hearing will be repeated or will not have to be repeated
No, it will
during the
be-
trial proper,
It
Your
will be
Honor.
automatically
Yes,
adopted. Oh,
it
okay.
be-
But my question is, forgo with the hearing and then resolve the petition for bail without any hearing. Can you do that?
Well, based on the rule-making power of the Supreme Court, I think it can be done, Your Honor.
But the Constitution says you have to determine the existence of a strong
Yeah,
evidence of guilt.
based on the evidence presented by the prosecutor, Your Honor.
It's like this, no? You file a case, assuming that what you said a while ago, if you adopt prima facie evidence.
Yes, Your
So
Honor.
if a prima facie evidence, you'll go to trial. The guidelines and the rules on the procedure, guideline and rule procedure, we now require the attachment of affidavits.
Yes, Your Honor.
So, in fact, the court will not issue a warrant of arrest if they dismiss the case if the evidence not complete. from the filing, So, can the court then say, anyway, I have the authority to issue a warrant of arrest based on the affidavits of arrest, evidence, the records of preliminary investigation attached to the information, and so on. Di ba?
Yes, Your Honor.
Can now the judge say, because I am allowed to determine the existence of probable cause in order to issue a warrant of arrest, I will use the same evidence in determining the existence. Kasi pag in-issue mo ng warrant of arrest, you already said that there is probable cause to issue warrant of arrest.
But-
So, can the court say, okay, I will set a hearing, no presentation of evidence by only oral arguments between the prosecution and the accused, based on the evidence attached to the information?
I don't think so, Your Honor. The judge cannot do that because the prosecution witness must be allowed to testify first, Your Honor.
But under our rule on guidelines, the testimony of the witness is already part of the records of preliminary investigation and attached to the information Nandun na lahat
But there is a right to cross-examine, Your Honor, based on
That's
the-
why I'm saying
Oh, yes, Your Honor.
That's why I'm saying, you set a hearing but no witness, but only oral arguments of the parties. He can argue his case He can use the affidavit. Anyway, this will also be the same.
Probably
In
they
fact, it's
can...
even better for the accused,
Yes, Your Honor.
for the
Probably
counsel of the accused to argue.
They
Because
can-
no witness will be testifying
They
It's
can-
better than the witness. So I'm the lawyer. I can base my questions, the lack of probable cause or the lack of evidence, strong evidence, I can prove to my oral argument because I have all the affidavits of the witnesses So can he do that?
I don't think so, Your Honor. The accused must have the right to cross-examine based on what was presented in the affidavit, Your Honor.
Which is better, cross-examined by the counsel of the witness or the hearing to be conducted by the judge himself and then ask questions from the fiscal about the existence of a strong evidence of guilt. Ano mas
But
mabuti
that
ron?
would be violative of the right to confront the witnesses, Your Honor.
Nandun
I
kasi
think it's trying in
It is
the...
an open hearing. The only difference is that there is no more witness. It will be based on the affidavits of witnesses nga We study that.
Yes, Your Honor.
Not yet to Justice GAERLAN. So you're in favor of amending the required evidence, prima facie evidence, in order to file cases.
Yes, Your Honor.
Now, the rules say that, as I said, you have to file cases even without a preliminary 4 years to 4 years 2 months. Okay.
For the MTC, Your Honor.
If you change the evidence from required evidence from probable cause to prima facie case, can we amend the rules and then say that all cases cognizable by the first level court should not be filed without any preliminary investigation? So the limit now is 6 years because that's the jurisdiction of the first level court. Instead of 4 years 2 months below, we will make it 6 years. So therefore, all cases filed before the first level courts will no longer undergo the required preliminary investigation and immediately file the cases based on a prima facie case. Do you agree with that?
Yes, Your Honor. I think the court can do that. I'm referring to the Supreme Court, Your Honor.
Can you do that now? Number 2 question. If I agree with you, is then there a need to amend the rule on summary procedure? If you do not anymore require PI for those crimes punishable by 6 years below, and then the threshold of evidence is prima facie case, no? Is there now a need to amend? Will there be a need to amend or even already take away the rule on summary procedure, because that is the essence of rule on summary procedure? Is there still a need to maintain the rules on summary procedure, or there is no more need?
I think there's no more need, Your Honor, to maintain the rule on summary procedure because we are now taking it.
But if you do that, if the penalty is less than 6 years, it's not covered by the rule on summary procedure, the court will now issue warrant of arrest, and you do not issue warrant of arrest under the rule on summary procedure.
Yes, Your Honor, but
what now?
But the court, I mean, the judge will still have to determine the
So
existence
that's,
of
that's what I'm asking you this, because that might be one of the topics that might be taken up by the Rules Committee. Because that would be the effect because we now require all cases filed before the first level courts, affidavits na lahat yan
Yes, precisely.
Wala nang law, direct testimony, affidavits na lahat yan. And that is summary. That's one of the effects of a summary procedure, or that's one of the purposes of a rule on summary
To
procedure.
expedite the
Ang
proceedings.
problema lang dyan, walang warrant of arrest sa rule on summary procedure If you amend the rule on summary procedure, kahit na slight physical injuries yan, warrant of arrest na yan. If you amend the rule on summary procedure, what do you say?
Well, in that case, Your Honor, we have to maintain then the rule and summary procedure, because the main purpose really of rule and summary procedure is to expedite the proceedings, because if we still have to require the findings of probable cause for purposes of warrant of arrest in cases covered under the rule and summary procedure, then that will be burdensome on the part of the judge, Your Honor, the court.
Justice Perez, please.
Yes, sir.
Yeah. Have you read, we published already the amendments on the rule of evidence last Sunday. Have you read that?
Yes, Your Honor.
Did you see the significance of the amendments on documentary evidence and object evidence? Did you read the enumerations on documentary evidence and object evidence?
What I recall immediately right now is the major amendment on the rule on original documents.
That's correct. It falls under documentary evidence.
That's right, Your Honor.
Under the old rule, documentary evidence only pertains to documents.
Yes, Your Honor.
Did you see the enumerations?
Yes, Your Honor. But
What does it include now, aside from documents? Pictures. Pictures, videos, even sounds.
that's correct, Your Honor.
Pictures, videos, sounds, they now fall under the category of documentary evidence. So what's the significance? Okay, let's have a picture. What's now the significance of that picture? Insofar as it now falls under the category of documentary evidence.
Well, then, firstly, Your Honor, its authenticity has to be proved in the same
Yeah,
manner.
that's correct,
as-
because even if it's a document, you have still to you still have to proceed in authenticating the document. di
That's
ba?
correct, Your
So
Honor.
you properly authenticate it. But what's the significance of having that picture being authenticated? Because you did not find that under the present rule.
No, it's not in
Documents
the
lang yun
present rules. That's correct,
Because they
Your Honor.
always say that the best evidence rule is the document itself, di ba?
That's
So what's
right,
now the
Your Honor.
significance of that picture, which
Well,
is now included in the enumeration?
Well, I think, Your Honor, the immediate effect of that is to dispense with the need for testimony of the person who.
I'll give you a problem. No? You have been handling a lot of drug cases, right? Yeah, you have a lot of drug cases. Every now and then, nare-reverse, di ba? Because of the strict application of Section 21, 9165, di ba? Now, the law says that within 72 hours, as under the rule, under the law, but most of the judges are not following because most of the cases involve small quantities. Within 72 hours, the courts have destroyed the evidence by, di ba? First, take the photograph in the presence of the accused, counsel, media, and so on, di ba?
Yes,
And
sir.
then take representative sample. That's
Yes,
what we
sir.
do when a case is already filed, right? Because
Yes, sir.
information is already filed there. So the inspection of the evidence and the destruction become part of the proceedings. That's part of the proceedings. It's equivalent to an inspection in civil cases. Ocular inspection in civil cases, part of proceedings yan. So under Section 21, if information is filed, then you go to the place, and then you record it, then as a example, that part of proceedings. That's why even if they destroy all the evidence, you take the photograph, that photograph will now substitute. Sino-substitute na niya ng host. That's what. But supposing those shabu or cocaine found on the seas, di ba? Confiscated by policemen. There are no persons arrested. right? There are no persons arrested. There are no cases filed. Do you follow me?
Yes, sir.
Yeah, there are no cases filed because the only way that the court will have custodia and custodial lehis of evidence would be by filing an information and then through a search warrant. Ito walang search warrant, walang case eh. Okay. Now it will now go to the policemen. Then they have suspects. They might have suspects, di ba? Right?
Mhm. Yes, sir.
Probably they identify the suspects, they file the case before the fiscal's office. Do you follow?
Yes, sir.
Now, the court cannot do anything as to the evidence is concerned because there is no yet case filed. In the meantime, there is apprehensions that evidence might go to, alam mo na, recycling and so on. That's what they say. Now, can the Department of Justice, no, and the PDEA probably come up with their own rules, in order to preserve the evidence, take the pictures, the same procedure if the case is filed, the same procedure. They get a media, because there is no yet accused, they get a barangay capte, they take pictures, and then get representative samples, then destroy the others, in order that they cannot be the subject matter of recycling. Can that be done? And therefore, you go to trial, you now use the pictures to prove that this is the corpus delicti, including the representative sample.
I suppose, Your Honor, with the new rule that admits pictures, videos, recordings, and all that as evidence in the same manner as we admit
So
documents in the trial.
that can now be done.
That can now be done, Your Honor, but with the present state of law right now, including the present jurisprudence, of course, we will have to redefine our concept of corpus delicti because right now the actual drugs are required to
No,
be
there is
presented.
there is an actual drug. They get representative samples. That's the purpose of the picture. That's the purpose of the amendment. The picture will not become the evidence in itself. So all those who are in the picture will have to testify. They will have. That's not the purpose.
Yes, Your Honor.
That will not
but
solve the problem. They can destroy even if there is no yet case filed.
I can see very well, Your Honor, the intent of the rule, but by way of caution, of course, I have to say that
But we can always presume regularity in the performance of duty.
That-
If they have their own rules, procedures, and they follow, coupled with the rules on evidence, which has to do something with admissibility of evidence, yun lang naman ang purpose natin ang
Yes, sir.
husgado. Whether or not that evidence is admissible So
incredible, Your Honor, if I may add.
that may be done.
That may be done, but I expect that the administrative or the seizing officers should very carefully and strictly follow their own procedure because the admissibility and credibility of those documents will
they
be
have to
at
do that
issue.
really. They have to be, in order that there must be a presumption of regularity, then they have to do it in a regular manner. Otherwise, that presumption will not apply to them.
That's
Of
correct,
course,
Your Honor.
with that caveat.
That's
Okay.
correct, Your Honor.
Okay, I'll go again to Justice Singh. Now we have provided in our rules, on admiralty cases, that we prohibit Rule 65. The filing of Rule 65 insofar as interlocutory orders are concerned. Can we do that in criminal cases? Can we require in the rules that Rule 65 shall not be available in these following instances in order to expedite the resolution of criminal cases?
Yes, Mr. Chief Justice,
And
even in criminal cases.
Why is it that we can do that? Of course, there must be a reason why we do not allow Rule 65.
Because it is within your power as the Supreme Court, the rule-making power of the Supreme Court is all-encompassing as far as procedure is concerned.
In a Rule 65, the resolution in Rule 65, it is merely on interlocutory order, right?
Yes, Mr. Chief
It
Justice.
is only an interlocutory order. So it does not dispose the case,
No,
the main
Mr.
issue.
Chief Justice.
So what's the harm?
But
If
the
we do
delay,
not file a Rule 65, will there be harm on the part of the accused? Anyway, it does not resolve the main issue.
we know, Mr. Chief Justice, from experience that a Rule 65 always causes delay to the main
That's correct.
action.
That's why I'm asking you if we can put that in the rules that Rule 65 is prohibited.
Yes,
In
yes,
some
certainly.
instances. For example, in a petition for bail, the denial in a petition for bail, if the bail is denied, can we put on the rules that Rule 65 is not allowed in a petition for bail?
Now, that is something else because it involves liberty. Perhaps.
What about in a motion for leave of court to file the demurrer to evidence? Can we do that?
No, after the denial of the demurrer,
Yeah,
Mr. Chief?
No. What is denied is the motion for leave of court
Even the motion
to
for
file
leave?
demurrer. Can we deny?
No, I think Your Honor, the Supreme Court can prevent the filing of Rule
What
65
about in
from
a
that.
denial in a demurrer to evidence? Can we prohibit the filing of Rule 65?
Certainly in that instance, Mr. Chief Justice.
Actually, Justice Lopez nga, tanongin ko nga. Can we, the same question as to petition for bail, a resolution of a petition for bail denying a petition, the resolution denying a petition for bail, can we put that on the, in order to prevent delay, can we put that in the rules that it's prohibited to avail of Rule 65?
Well, as stated by Justice Singh, it involves liberty. And the Constitution itself says that if there is a
Supposing I
abuse
say,
of discretion, it might be brought to the higher court.
supposing if I'm the judge, I say, I deny your petition for bail. Anyway, you can reiterate it at any time of the proceedings. And in other words, I am denying your petition for bail on the ground that the evidence of guilt
It's not strong at that time.
is strong. Dinenay ko
It's
nga
strong,
eh.
yeah,
The evidence of guilt is strong. And then he says, I'm filing a motion for reconsideration. We will proceed. Anyway, you can reiterate your petition the petition for bail at any time of the proceedings. Can I not do that?
Yes, Your Honor, I think.
So
you
will
can
there
do-
be a
yeah.
grave abuse of discretion if I will deny your petition for bail? I mean, I deny your motion for reconsideration on the resolution on
Well,
the petition
because
for...
certiorari requires that there is no other remedy.
Kaya nga sinasabi ko nga,
instance,
that's why I'm
Your
not
Honor.
telling you.
Yeah,
If that
yes.
is my resolution,
Yeah,
I
that
say
will be fine, Your Honor.
I'm denying your motion for reconsideration because I will say that there is another remedy which you can reiterate.
Yeah, I agree with the Chief Justice, Your Honor.
Why does it become final? A petition resolution, a petition for bail
It's not,
does it become
it
final?
depends on the quantum of evidence required. If there is
What?
already, if the evidence of guilt is already strong, Your Honor, it can be denied. And if not,
No,
at
the
any
re-
point in
the-
time, Your Honor,
The resolution in a petition for bail, denying a petition for bail, that resolution can become final.
no, not Your Honor.
There is no finality,
Yes,
Judge,
yes,
interlocutory
yes, yes.
order. So it can be
Yes.
raised at any time.
Yes, Your Honor.
So we can prevent Rule 65 because it can be reiterated at any time.
Yes, Your Honor.
Can I do that?
Yes, Your Honor.
Let us see. Tatapusin mo. I just finished, ha? I enjoy, asking questions. Because he will join us later on, and, one of my programs is speedy disposition of cases, both in criminal and civil. So I just want to ask some pointers from you, or suggestions, so that probably we can incorporate. Anyway, you're still young, so you have a lot of wisdom. So justice, justice Ami. In the court of appeals, I have to tell you this because this is what we have been hearing and then what we have been doing, that in the court of appeals you do not conduct any actual deliberations. Now in the court of appeals we heard, and then I myself have personal knowledge that inhibitions you have no strict rules on inhibitions. Only the mandatory inhibitions probably are being followed, but inhibitions are granted indiscriminately. Even if there is no motion, just mere say so, the party or is my classmate, fraternity brother, and so on, mag-inhibit na eh. Di ba?
Yes,
Tama.
Your Honor, that's a practice,
Now,
Your Honor.
Is the Supreme Court empowered to impose upon the members of the Court of Appeals to have an actual deliberations and also deliberate on a motion on an inhibition of the party? Because that's what we are doing in the Supreme Court. You have to tell the members why you're inhibiting. And it's the members that will tell you if you inhibit or not, especially if it is not a ground of mandatory inhibition. So are you in favor if the Supreme Court will remind you that you have to come up with this, you have to follow strictly
Yes.
deliberations on all matters, including inhibitions?
Absolutely, Your Honor. It is within the power of the Supreme Court.
That is your commitment.
Yes, Your Honor. In
Because
fact, some of the chairman of the divisions are already doing that, Your Honor.
and do you
that-
tackle also inhibitions?
Yes, Your Honor.
Do you decide inhibitions or it's
Oh, no, no,
it's
no,
only a
no,
matter
no,
of
no.
choice?
It's just only a matter of choice, Your Honor.
Uh,
But
that's
now
why-
that I'm now chairman of the 17th Division, probably I will
I think that's
I will
better because we hear
take
a lot,
that as a
hear-
guide.
we,
Your Honor.
we hear a lot of inhibitions just because they are fraternity brothers, classmates, friends, and so on. We do not do that in the Supreme Court. If you say that he's your classmate, then the Supreme Court will say, no, you are not supposed to inhibit. That's not a ground. That's what we do. That's why we are of course, we are a little fast in resolving cases. We have more cases than you are.
Yes.
We have at least, we receive around 700 cases a year, aside from our work as members of the different committee and lecturers or chairmen of the different committees. More than. I think right now if there are vacancies. We receive something, the justices, except the Chief Justice and the Chairman, they receive something like, sana si Ed, alam ni Ed yan eh. Mga ano yan, mga 12, 18, mga 80, 60 to 80 cases a month. No, we will not be withdrawing, but that's the reality in the Supreme Court. So last question for everybody. I don't know if this has been already asked. Just have you been asked a question? Why do you want to join the judiciary? I mean the Supreme Court. You have also that. You have already been asked that question, so I want to ask that question for everybody. We start with Justice GAERLAN.
Well, Your Honor, I have been in the judiciary for 26 years. I started as a municipal trial court judge, then so I rose from the ranks. So it has been my dream then, even right now, and which is the dream of every lawyer, to be in the highest court of the land, which is the Supreme Court. So that precisely, Your Honor, prompted me to apply to the Supreme Court as Associate Justice.
Just like any lawyer, Your Honor, it is the dream of any lawyer to become part of the Supreme Court, number one. And number two, probably as part of the Supreme Court, you might be able to do something for the legal profession, Your Honor, and to the practice, pleadings, and admission to the bar, because these are part of the job of the Supreme Court members, Your Honor. And lastly, of course, there are some rules and jurisprudence that need to be changed, Your Honor. I could be part of it, Your Honor.
Your Honor, I look upon this opportunity as a duty that every lawyer who is convinced that he has reached a point in his life where he has gained some experience, skill, competence, and so forth, should offer himself to the service of the judiciary.
Mr. Chief Justice, I want to help. I feel that I can help adjudicative and also in terms of the reform work that the Chief Justice is very passionate about. But also, Mr. Chief Justice, because I feel strongly that we have to show to the people that we are deserving of their trust and confidence. I think that's the thing that we all most want. And so if I am able to contribute to that, Your Honor, I think then it will be a life well lived.
Are there other questions from the other members? No more? So that's all for me. Good luck. Ano, Oh, go ahead.
Thank you. A few questions only. Thank you for the insight. Justice GAERLAN, because still on record, this was not as the last time you were interviewed. Feedback which we received dated June 28, 2007 is still on record, stating that sa 50th Division of Court of Appeals na pinumumunuan ni Norman D. B. Pizarro at kinabibilangan ni na Samuel Garland at Joseph Lopez, ang mga apilang inuuna ay mga apila ng mga partidong nagbabayad para unahin sila. At ang mga apilang ibinabaon sa limot ng ilang taon ay ang mga apila ng mga partidong natalo sa RTCs na nagbabayad para huwag madesisyonan ng ilang taon ang kanilang mga apila at para huwag ma-execute ang mga desisyon ng mga RTCs laban sa kanila, bilis o bagal ng hustisya. Depende sa bilis o bagal, kwarta na, sobra na, tama na, sa pwesto sibakin na. This is the best opportunity for both of you to comment on this negative feedback.
Your
Justice
Honor,
GAERLAN.
okay. Your Honor, I was aware of that in my first application then, Your Honor. And that's the reason why I did not, I merely ignored that, Your Honor, because for me, I don't have to answer that. In the first place, it was just a anonymous letter, and at the same time, I maintain, Your Honor, in deciding cases, which I'm sure Justice Lopez will bear with me, because we were the ones alluded to in that anonymous letter, Your Honor, that I know my the priorities in deciding cases, and I stick to that, Your Honor. I was not bothered then, Your Honor, and even right now, because of that letter that I have to decide cases and have to choose or select cases. I observe, Your Honor, the hierarchy of cases which are submitted to me for decision.
And Justice Lopez, you're the only Lopez left now. The
Yes,
other
Your Honor, I
Lopez is
suppose so,
already
Your Honor.
appointed.
Well, number one, as pointed out by Justice GAERLAN, it was an anonymous letter. In fact, it was sent to all justices of the Court of Appeals. I don't know for what reason, but just the same, this same letter was sent to the Supreme Court. The Supreme Court required
RTC, and I think there were two when I was in the RTC, Your Honor, and all of them have been dismissed by the Supreme Court, except for one when I was in the Med-C where there was an admonition. And to the point only, Your Honor, that I am really an innovator, and I adopted many strategies that were new at the time, which I am very happy to see have become mainstream already at this point in time. But at that time, they were very novel, and so a lot of, well, I guess a lot of litigants were surprised, were not in, well, were not in agreement with my innovations, and so that resulted in several of these cases being filed against me. But as I said, Your Honor, they have been duly acted upon by the Supreme Court.
How about you, Justice Babs Perez?
Yes, sir.
In relation to case number, administrative matter number 17-01-01CA by certain William Giuliani, there is a letter request by the said person for investigation on the conduct of Honorable Camelio, Badilles, Martin, Inting, and Perez, Associate Justices of the Court of Appeals. That's still pending at the Supreme Court. What's the status? Any update on this case filed against you?
Your Honor, the case is still pending. This is the only administrative case pending against me. This involves 5 or 6 members of